Good day. We're back again with environmental law, and we're going to deal with lesson 5, the legal framework for environmental law in Zimbabwe. We're going to deal with section 73 of the Constitution, the interpretation of that right. We're going to break down that right and try to interpret what it really means to have the right to a safe and healthy environment. Now, we are familiar with the international recognition of such a right. At an international level, we see that there's a general acceptance of the anthropocentric approach that we ought to protect the environment for the betterment of humanity. That is the global approach to interpretation of rights. And it is that same approach that comes in Zimbabwe. Now, before we go on to deal with the section, we are familiar with the group of rights that are there. There is the first generation or civil political rights of individuals. Examples of that right include the right to equality, the right to life, the right to freedom of association. These are the conventionally enforced rights that are enforced in a negative fashion, in that individuals enjoy such rights without having the state provide anything, right? The state merely has to refrain from infringing these rights, right? So they are negatively enforced. And then we have positive rights, which need positive enforcement. These are the second generational rights, the social, economic, and cultural rights. These rights include the right to work, food, and housing. They need positive action by the state to ensure that these rights are there, right? And then we have environmental rights or third generational rights. These are the people's rights. These rights are of the public at large rather than rights of specific individuals. So they are enjoyed on a public sphere, on a public scale, right? This includes environmental right, the right to development, the right to peace, and so forth. So we are now going to look at the environmental right. Section 73 of our Constitution says that every person has the right to an environment that is not harmful to their health or well-being, and to have the right and to have the environment protected for the benefit of the present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, promote conservation, and secure ecologically sustainable development and use of natural resources while promoting economic and social development. The state must take reasonable legislative and other measures within the limits of the resources available to it to achieve the progressive realization of these rights. Now, generally, there are two kinds of rights that are there. There are two kinds of environmental rights that are there. The right of humans to have a safe and healthy environment, and the right of the environment itself not to be degraded, right? Those are the two kind of rights that are there. And the right of the environment itself not to be degraded was proposed by Christopher Stone in his paper where he asked this question: should trees have standing? Right. So he's posing that the environment itself should be protected in its own right. Right. Um, yeah, this approach globally, not a lot of countries have accepted that approach to environmental rights, and most countries and most states, including Zimbabwe, welcome the rise of humans to a safe and healthy environment, as you can see from the terminology. That is the type of environmental right that we are exercising in Zimbabwe. Now, in terms of the right itself, that is in our constitution, we see there is a vertical versus horizontal application. Not only are we supposed to apply this right on a horizontal application, but there's a vertical application as well. The state must ensure that we have a healthy and safe environment, and each other we should not um, we should not instill unsafe, unenvironmentally safe environments on other people, be it through noise, pollution, or anything of that sort. So here it says that the inclusion of the term health or well-being, notion of physical or mental health. Now, when we are trying to define, here it says that not only the right to a safe and healthy health or well-being, right? We are trying to keep the environment safe for our health and well-being. What does it mean for our health and well-being? Um, Firstly, we have to ensure that this right to a safe and healthy environment um, is different from the right to the access of healthcare services. It should be separated, right? And then what does it mean that we have to keep the environment safe for our well-being? What does it mean to have a well-being? Well, in the case of HTF developers versus the Minister of Environmental Affairs, the South African case, they were trying also to give a definition for what does it mean um, to have the environment be not harmful for our well-being. The state stated that well-being should be defined in an open-ended and manifestly incapable of precise definition. So it has to be open-ended. Though we cannot precisely define it, nevertheless, it is critically important that it defines for the environmental authorities the constitutional obligation to that task. Right. So we should define it in an open-ended way. And then Glazowski, in his book, says that the potential ambit of a right to a well-being is exciting but potentially limitless. Right. And what does well-being encompass? Well, the potential is limitless in that regard. That's what Glazowski says. And in another case, the case written there, the Cape Produce Company case, the court stated that exposure to a stench was also regarded as adverse to one's health and well-being. Right. So here they were saying that the well-being part should be open-mindedly defined and should also include a stench, right? Just a smell. It's so pungent and so strong that it affects one's health and well-being. Then it also is encompassed in environmental rights. Now, when we're looking at the right itself again, we see also the principle of intergenerational equity, which is also one of the principles under sustainable development. We are saying that it is for the benefit of a present and future generation. So the principle of intergenerational equity is also present there. And then the obligation is on the state and in individuals, right? So there's a duty on every citizen to protect and improve the natural environment, and also a duty on the state for the progressive realization of environmental rights. Right? The state now says that they have to. The last section says that the state has to progressively realize this right, and there's an obligation on the state to ensure that realization. Right? What does the incorporation of environmental rights in the Constitution, how does it impact uh, the implementation and enforcement of that such a right? Well, the case in Save the Val environment case, they were talking about the incorporation of environmental rights into the Constitution and how it affects uh, how it affects the administration of the state. It says that our constitution, by including environmental rights as fundamental, justifiable human rights, by necessary implication, requires that environmental consideration be accorded appropriate recognition and respect in administrative process in our country. So all administrative process, even in the country also Zimbabwe, we're expected also to consider environmental rights, right? It says that the decisions that are taken by the administration, by the state, should consider as well environmental rights. They should not conflict with the environmental principles that we are familiar with, right? So all those things have to be have to be noted, right? What had happened in this case, well, you should read up on the case. It's quite interesting. The applicant brought the application under Rule 53 against the first respondent to review and set aside the decision of the first respondent, right, whereby he granted the fourth respondent a mining authorization under Section 9 of the Minerals Act for the establishment of an open-cast mine in the vicinity of the Sasolburg. The license would permit the respondent to mine on the riverbank of the Vaal River. The respondent opposed the application. The complaint was based on the first respondent's failure to give the applicant an opportunity to be heard prior to the first respondent making a decision to issue a mining authorization. The court declared that the applicant could not prevent the first respondent from taking a decision he considers appropriate for the optimal utilization of resources, but that he had the right to make a representation and to be heard before the respondent took the decision to grant the license. The matter was remitted to the first respondent to consider the application, to reconsider the application afresh. So we are looking at the fact that administrative decisions have to consider the environmental impact. When a development is about to be done, we have to look at they have to have had the respondent's case. The respondent had the right to make representations, right, over that case because of the environmental impact that it was going to have on them. So the court stated that the applicant had to reconsider his decision. Now, as you can see from the previous case that we just stated, there are also various implications that the right to environment has. It also it is entangled with other rights as well. The right to standing, who now has to go to court and exercise this environmental right. Section 24 affords the applicant legal standing to seek redress for contraventions of the Declaration of Rights only in relation to itself. So we have Section 24, which is saying that, so not Section 24, we have Section 85, which gives the right to stand if your right to a safe and healthy environment has been contravened. We have Section 85, which talks about the enforcement of fundamental human rights and freedoms. And any of the following persons, namely any person acting in their own interest, any person acting on behalf of another person who cannot by themselves, any person acting as a member or in the interest of a group or a class of people, all these people have the right to seek redress for any infringement of their environmental right. And then this happened in the case that we told, in the listed case here, the Satellite Television Users Association versus Post and Telecommunication Operation. The court says that where such power is given to the court cannot interfere on the main ground that it considers the fee highly. So in this case, we are looking at the fact that the court, in terms of Section 73, not the court, the provision in the Constitution says that the state should progressively realize this right? To progressively realize this right. And to what extent now can a person then go to court and say, because the state has caused or has allowed for an unhealthy and unsafe environment to occur, it has failed in the progressive realization of this right? Can a person now go to court and say that, and is the court permitted by law to force the state to create policies in that regard? Now, the such a legal principle was looked at in this case, wherein we have now the court had to consider whether the size of a license fee was too great a size, or for was too great a size, and whether the was it the telecommunications corporation had given a too great a size, and whether they should lower that license fee, right? We are now looking at the principle of separation of powers. Can the court now tell the executive how to what extent to administer the state, right? Can the court now say, the extent to which you are ensuring environmental protection is so low, you should do it in this way? We're now looking at the principle of separation of powers now. Can the court do that when it is only their job to interpret the law and to apply the law, right? Now, the court had to consider that in this case, and say that where such power is given, the court cannot interfere on the mere ground that it considers the fee unreasonably high. The size of the fee, however, might in certain circumstances be a factor in considering whether the council genuinely exercises its power of licensing and regulating, or malified used such power for achieving an ulterior object such as prohibition. For instance, the council might prescribe a fee so outrageously high that only reasonable interference was to prohibit the business in question entirely. So in this court, they were saying that though we cannot interfere on the mere fact that a license fee is too high or not, we cannot do that, but we can look into whether the council genuinely exercised this power. Now we're looking at the administrative procedural fairness part of it. The court can interfere whether the decision, how that decision came about, was fair or not, but they cannot look at the content of the decision itself, right? Or alter it, because in doing so they are now administering the state, which is not part of their job. Now, other pertinent constitutional provisions, as noted before, the locus standi section 85, the right to access to information, all those other rights are, help in the achievement of environmental rights. The right to administrative justice, right? Procedural fairness in the decision-making process of a potentially environmentally harmful project is important, right? We see that in the Save the Val case, right? The need to hear all interested parties, the need for public participation, and so forth. All those things are speaking to right to administrative justice. And it is this right that will ensure that there is the right to a health and safe environment. I mean, the right to property rights, we have the right to food and water, human dignity, right to life, interpretation clause, the limitation clause. All these really somewhat connected to environmental protection, one way or the other, to ensure that we all have a safe and healthy environment. Now, looking specifically to the right to information, section 62, Nima also notes on that and says that environmental education, the right to be informed of executive decision. Every Zimbabwean citizen, permanent resident, including juristic and the Zimbabwean media, has the right to access information held by the state or institution or agency at every level, insofar as the information is required in the interest of public accountability. So we're looking at this right saying that we should ensure that there is environmental education and be informed of executive decisions that are going to negatively or even positively affect the environment, right? So this right speaks to the need for environmental enforcement, and it speaks all to the right to environmental protection. Now, not only is environment protected by the Constitution, there are other legislative measures put out by the state to ensure environmental protection. We're going to look closer to those legislative measures, and more especially, we are looking at the Environmental Management Act, Chapter 2027 of our country. We are going to look in depth the key provisions therein, the objectives of the act and the institutions that were established as a result of the act. We are going to look in detail with these ones. So this is it. So this is it, ladies and gentlemen. This is the right to a safe and healthy environment interpreted in terms of section 73 of the Constitution. It looks at the anthropocentric environmental right approach, and it has a vertical and horizontal application, and it looks at the interpretation of what does it mean to have a cell to ensure the a safe, healthy or well-being. What does it mean? Does it also include stench that South African case talked about? They should be broadly interpreted just like Glasowski talks about, and the fact that it is limitless in interpretation. And then we look at the other clauses that help in the interpretation and application and implementation of the right to a safe environment, like the locus standi provisions. We look at the right to access to information, the right to administrative justice. All these are trying to ensure environmental protection. Thank you.